Welcome back to the last session of business laws. So far, out of 6 blocks, we have covered 4 blocks in totality and 5th block in partial. Today, we'll be exploring the relevant contemporary topics. One that we all are facing, that is regarding data protection. Another one, environmental protection and sustainability. Interestingly, the concept of competition law in business laws has been evolved over the period of time. So it is also a contemporary and relevant topic. And the last one is also consumer protection law. In fact, the last unit is something that deals with the other part of business, the consumers. So a businessman should not be a cheater. He should not provide inefficient services to the user or product to the user. So the rights of the user, that is in this case considered as a consumer, is also protected under the laws. And these laws are also evolved over the period of time. So definitely in today's session, we will be exploring some of the very, very relevant, contemporary, and interesting topics. Well, the data is a basic unit of any database, any information, relevant information, and a combination of data sets or components in a data sets or a database in total may be used for n number of uses. Usually, these data units or individual components of a database may be very personal. It may be related to name, father's name, date of birth, PAN card, Aadhaar number, or other things. The combination usage of these in data sets or data may be detrimental to the privacy, safety, and security of an individual. In order to address it, there are evolving processes regarding data protection and privacy. I'm sure you have ignored the terms and conditions many a times that are mandatorily for you to mark, I accept it, I read it, or I'm in agreement with them, that come across during the acceptance of terms and condition of any software, passing to the next stage in any on any web page. So usually under those clauses, sub-clauses, and conditions, there is a clear-cut introduction of what kind of data is being received and what are the liberties that you are offering to the collector, or what are the liabilities of the data collector, how the data will be stored, how long it will be stored, and how they can use your data. Usually you see there are pop-up mails, pop-up message on your screen whenever you are using your desktop or mobile, and they give you information that you can receive from your information may be shared with the contemporary business players, or you can receive business mails, promotional emails, in fact, regarding the products. So through these processes, your data is basically collected, shared, and that too with your consent. And many times we remain ignorant what kind of consent we are giving, or what should we not, what are rights, how much we can deny or so. Basically, this entire unit is dealing with that entire aspect. We all understand that privacy is an evolving concept in the digital context. One of the primary factors that necessitated the evolution of privacy rights was the need to safeguard and preserve the dignity of an individual and consequently preventing unauthorized disclosure of personal information in the public domain. Well, there is a very good definition of this, and which says that privacy is a concept encompassing the inviolate personality of a person, which does not include within its ambit matters which are privileged, published with consent, or existing in public domain. Well, in Indian context, in Indian context, that definitely the privacy, the concept of privacy is in the evolving phase, because many of the things you can imagine when Constitution was framed, when most of these things was not there. So this is an evolving process. So over the period of time, on the basis of certain judgments, on the basis of certain situations, it is continuously in the process of evolution in case of Indian context. And on the continuous processing, the government formed a committee of experts under the leadership of Justice B.N. Shri Krishna to consider all issues related to data protection and come up with a draft regulation thereon. And one is called as Information Technology Act and the Right to Privacy. This act in 2000 will have implications for privacy protection, and Rule 3 of this Act of 2011 gives the definition as sensitive personal data or information means such personal information which consists of informations relating to password, financial information such as bank account or credit card or debit card or other payment instrument details, physical, physiological, or mental health condition, sexual orientation, medical records or history, biometric information, any detail relating to the above clauses as provided to the body corporate for providing services, and any of the information received under above clauses by body corporate for processing, stored, or processed under lawful contract or otherwise. Well, there are specific provisions in this, which includes maybe companies or the personals which require personal, non-personal data information. And as far as this framework for the data protection is concerned in India, specifically in the Puttaswamy decision, the Supreme Court had categorically mentioned the need for an appropriate data protection framework in India. Well, in July 2017, Indian government decided to form a committee to study various dimensions of data protection and suggest inputs of an appropriate legislative framework in the area. Under the chairmanship of Justice retired B.N. Shri Krishna, the committee gave a comprehensive report delineating the rationale for the robust legal framework for data protection, and the committee also provided a draft personal data protection bill in which the person who is that is considered data fiduciary to follow the principles of certain principles need to be followed by the data fiduciary: purpose limitation, provide notice, storage limitation. As far as the purpose limitation concerned, data fiduciary shall use the personal data, collect only for the purpose for which the data principal expects it to be used, transparency, providing notice right at the time of collection of personal data, and storage limitation, storage of the data only for the time period required to fulfill the purpose for which it was collected. Processing cannot be performed in the absence of an express consent by the data principal unless the purpose for the same has been communicated at the time of collection. Well, at the same time, the committee also recommended the inclusion of data principals, rights to correction, object to processing, confirmation, data principal's right to inquire about the processing of his personal data, data portability, right to receive and transfer the data stored with the data fiduciary, access right of the data principal to obtain access to his personal data in the control of a data fiduciary, object to data marketing, and be forgotten right of the data principal to delink, amend, or correct the information that may be disclosed on the internet by the data fiduciary. So there is in additional the Data Protection Bill of 2019 introduced in Lok Sabha, and it was subsequently forwarded to Joint Parliamentary Committee (JPC). While the bill has retained many elements of the draft bill provided by the Sri Krishna Committee, it also made some radical changes. The definition of personal data, which was defined in a way so as to include characteristics, traits, or attributes of identity used to identify an individual, was expanded to also include any inference being drawn from such data for profiling purposes. So it was an interpretation aspect that was added to it. Well, the composition of Data Protection Authority was also subjected to certain modification in the 2019 PDP bill, and the selection committee, as per the approved bill, consists of Cabinet Secretary as chairperson, Secretary Department of Legal Affairs, Secretary Ministry of Electronics and Information Technology. Well, now move to the next block, last block, which contains 3 units: environmental protection and sustainability, competition, and likewise. Well, in the related to unit related to environmental sustainability, we all understand over the period of time, we all are concerned about our environment. We are facing regular changes in the surrounding environment due to anthropogenic activities. So with the Stockholm Declaration adopted in UN Conference on Environment in Stockholm in 1972, which placed environmental issues at the forefront of international concerns and marked the start of a dialogue between industrialized and developing countries to link between economic growth, pollution of the air, water, oceans, and well-being of people around the world. Well, in this context itself, in 2030, the agenda for SDG, that is called as Sustainable Development Goals, that are adopted in 2015, include 17 Sustainable Development Goals specified as SDG 93 and SDG 124 puts the onus of sustainable development not just on the governments, but also on other stakeholders like industries, businesses, and consumers. Under the International Framework for Climate Change, Kyoto Protocol, and Paris Agreement have both called for the financial assistance from developed countries with more financial resources to those countries that are more vulnerable and less financially endowed. Well, the global economy is continuing to grow, and by 2050, it is possible tripling of resource extraction. There's a widespread increase in population, especially in developing countries, where the current world population is 7.3 billion, and it is expected to reach 9.7 billion by 2050. And there's an increase in global consumption, manufacturing, pollution level, and we are nowhere near to achieving the target set at the Paris Agreement. That is, and also we are expecting 1.5 degrees Celsius increase in the temperature, which will further aggravate the negative impacts on environment, livelihood, and health, including the agricultural activities, because we all understand, we are very much familiar. Any change in temperature will definitely affect the crop yield as well. Well, over the period of time, there has been an evolution of environmental protection legislation in India. And we can see like Air Prevention and Control of Pollution Act 1981, Water Prevention and Control of Pollution Act 1974 were introduced. Further, under Article 14.8A and 58G were incorporated in the Constitution by the way of 42nd Amendment in 1976. Well, there are constitutional provisions for environmental protection, and it is basically, you can see the Indian Constitution may be considered as a living document which has evolved and grown with time. and substantive provisions for environmental rights and duties were lacking in our original constitution because it was not a point of consideration at that time. It was not at all required, and industrialization was not at that pace at that time, and definitely it was not a concern or not a considerable concern, not only to us but also to the global players as well. Well, in the uh, uh, in the way of 42nd Amendment, we see which introduced specific provisions for environmental protection in the form of directive principles of the state policy and fundamental duties. We understand the things have been evolved and adopted in the Indian Constitution as well. Well, the Article 21 of the Indian Constitution states that no person shall be deprived of his life or personal liberty except according to procedure established by law. And this is the most important article through which the pollution has been putting under control, because any act which increases the pollution level definitely affects the life of other individuals. So it is directly or indirectly violation of Article 21. So that's why all the things are attempted to put in the place. Well, public interest litigation in Article 32 and Article 226 also resulted in the wave of environmental litigations, producing a rich environmental jurisprudence in India. Thus, India's constitution now guarantees a right to healthy environment, right to clean air, and right to clean water. Under Article 19(1), subsection G of the Indian Constitution confers fundamental right to every citizen to practice any profession or to carry on any occupation, trade, or business. However, it is subject to reasonable restriction. In the case as Pura Bazaar Fireworks Dealers Association was a Commissioner of Police, Calcutta, it was held that this article of the Constitution of India does not guarantee the fundamental right to carry on trade or business which creates pollution or which takes away the community's safety, health, and peace. Well, the environmental framework in India and its impact on business and industries. There is the Environmental Protection Act, Water, Air, and Wildlife, Forest and Wildlife Protection Acts, which somehow seems to be affecting the business. Like we talk about water, air, Environmental Protection Act, and as far as the air pollution, water pollution, and other acts like soil pollution as well, every industry should mandatorily disclose what is their raw material and what is their product, what is their byproduct, what are their wastes, and how they are attending their waste. So they are not free to pollute the air. They are not free to pollute the discharge in the sewage system. They have to treat it. They have to treat their air. They have to treat their exhausts. They have to treat their water discharge, and whatever waste they are producing as a pollutant need to be treated, and they should ensure what is the method they are following. It should be displayed as well. In this regard, so every industry should have need to additionally incur some cost, because if you are putting something in your industry which is not directly productive to your functioning, it is adding to your cost. But that is mandatory provision, so it adds to the cost, but at the same time, it may be directly and indirectly helpful in the improving the life of the citizens in that area, because if you are preventing air pollution, definitely air quality is improving and the health is also improving. If you are preventing water pollution, definitely water quality is improving, and living is also improved in that area. So similarly, there is also Coastal Regulation Zones Notification 91, which defines the coastal zones under Zone A1A, 1B, second, third, fourth accordingly. And there is a restrictions of activities on those areas, like zone 1A is ecologically sensitive area, 1B is intertidal zone area between high tide line and low tide line. Zone 2 is developed areas up to the close to shoreline. And the third one is land areas that are relatively undisturbed, have further divided into A and B based on population density. And the zone 4 is water areas and seabed areas. And it is also further divided into A and B depending on their distance from the low tide line. Well, then there are waste management rules. As I mentioned, that every industry should ensure or mention what is their waste and how they are managing. In addition to this, there is also a concept of waste management by municipal bodies. So they explore the options for solid waste management, plastic waste management, hazardous waste management, and also biomedical waste management. So as per the biomedical waste management provisions, every industry, medical industry specifically, need to ensure how their biomedical waste is being attended. And definitely in this sector, the industry, some new players are encouraged to take up this kind of industry, and I think there are some tax reliefs also those who are involved in the waste management. And in addition to this, there is another concept of e-waste management also that is upcoming field. And luckily, one Indian entrepreneur has got a good number of patents in recycling of electronic waste, specifically mobile phone and laptops and desktops. So they are doing reverse engineering sort of thing, and they are getting back the raw material or the components from these wastes, which are definitely generating over the period of time. And another important act in this context is environment impact assessment. So this is related to the concept that uh, there is a categorization of industry that can be set up. Before setting up of an industry in an area, it needs to have a mandatory clearance of environment impact assessment. So what is the prior condition of that environment, and what will be the effect of that industry in that area, and what is the alternate if the changes that will be incurred on an area due to that industry can be minimized by some process that need to be followed, and only if it is cleared by the EIA, only then that industry can be set up in that area. And there are Forest Conservation Acts, Wildlife Protection Act, and relevant as one as well. So then there is a concept of implementation, compliance, and enforcement. So any good government requires the establishment of viable institutions with adequate powers and component personnel with that knowledge and means to deal with challenges while keeping public interest in mind. This is especially true in case of environmental protection, which requires specialized scientific knowledge while dealing with various aspects of pollution. Well, good government, enforcement, and compliance. Well, there are judicial forums for environmental protection and liability corporates. As per Supreme Court, the polluter pays principal demand that the financial cost of preventing or remedying damage caused by pollution should lie with the undertaking which caused the pollution or produce the goods which caused the pollution. There is addition to this framework that is called as National Green Tribunal. It was established as a statutory tribunal in year 2010 with the objective to make environmental justice accessible, effective, expeditious in India. And we often see there is a regular judgments, directions from the NGT on various aspects, including pollution, including vehicles, including environmental related issues. So NGT has been proactive, and interestingly, there is a area demarcation in which its rules are operative across India. And NGT is proactively involved in the environmental related legislation or environment related cases primarily. As far as the concept of climate change in India is concerned, India launched its National Action Plan on Climate Change way back in 2008, and it has a leading host country of clean development mechanism investments, enabling countries to invest in emission reducing projects, thereby earning certified emission reductions. Well, India has emerged as second largest beneficiary to China in CDM projects. Well, its shares in CDM projects is around 20%, whereas China is 50%, and share in CARs is 13%, whereas China is 60%. The opportunities of CDM in energy sector, electric vehicle sectors are many. Well, India submitted its intended nationally determined contribution in October 2015, which gives an outline of post 2020 climate actions that the country shall take. Well, India is a founder member of International Solar Alliance, launched in 2015 itself. Recently at COP, India made announcement of new climate action targets and has indicated that it shall be carbon neutral by year 2070. There are certain encouragement scheme which we can consider market-based measures, like Perform, Achieve and Trade, PAT scheme, a flagship program of Bureau of Energy Efficiency under the National Mission for Enhanced Energy Efficiency, NMEEE. Green bonds, as on February 12, 2020, the outstanding amount of green bonds in India was around US dollar 16.3 billion. SEBI on March 21, as per its business responsibility and sustainability report, there are 1,000 listed entities by market capitalization to mandatorily disclose resources usage like air emission, waste management, and compliance with EPR and PAT scheme. Well, as per MSME, it has promote new and green technologies by providing subsidized loan, encouraging that technology in the upcoming sector. We are familiar that MSME deals with the micro, small, and medium enterprises. So it acts as a platform where the new entrepreneur or established entrepreneurs can interact and especially take up the newer and greener technologies. Well, then there is zero defect, zero effect certification scheme. Well, after Z assessment can reduce wastage sustainability, increase productivity, expand their market. As IOPs become vendor to CPSUs, have more IPS development processes, new products, etc. Well, there are schemes promoting innovation, rural industry, and entrepreneurship, that is SPAC, and promote startups for innovation in agro industry specifically. And credit linked capital subsidy for technology upgradation, that is called a CLCSS. It is to facilitate technology upgradation in MSCs by providing an upfront capital subsidy of 15% on institutional finance of up to ₹1 crore availed by them for induction of well-established and improved technology in a specified subsector products that are approved. Then there are certain important developments as well, like environmental audit. Well, it is a mandatory, but some states as Gujarat, Maharashtra, Karnataka offer incentives to industries units obtaining an ISO certification in the environment category. The incentives are longer validity period for the consent, authorization, expeditious clearance for renewal plans, applications, etc. Well, these efforts need to be coordinated at the national level to provide the necessary catalyst to develop sustainability. Well, let's move to the next unit, that is competition law. Competition law, which is also referred as antitrust law in some jurisdictions, play a pivotal role in ensuring smooth functioning of a dynamic market economy. They are concerned themselves with firms enjoying undisputed market power, which opens up the possibility of hindering consumer welfare by increasing prices, reducing output, diminishing product quality, and suppressing innovation. As far as brief history, we can say the Indian Constitution is drafted carefully with several measures aimed at safeguarding diverse rights that can be contributing to the flourishing of the country as well as its citizens. Article 38, 39, though having been placed in Part 4 of the Constitution as directive principles of the state policy and unenforceable in the court of law, have proven extremely significant laying down directions for good governance of a state. Previously, there was a Monopolies and Restrictive Trade Practices Act that was 1969. As per this act, to control monopolies to ensure that the economic system does not culminate in concentration of economic powers and to disallow monopolistic and restrictive trade practices. It has highlighted the second phase ranging from 1991 to present was bringing forth market-oriented economic policies which was coming up in the form of new economic policy that needed to be in tune with the rise in that globalization, liberalization, privatization, that is LPG we call as policies. As per Raghun Committee report, they seek to shift focus from restraining monopolies to the promotion of competition was one of the primary reasons for the MRTP Act becoming obsolete, thereby paving way to new legislation that ensured for the appointment of high-level committee, competition policy and law in 1999, which is also often referred as a Raghun Committee. The committee was responsible for providing suggestions for the establishment of suitable legislative framework for competition law and recommended changes in relation to restrictive trade practices. Thereby, Competition Act in 2002 was enacted, which was definitely based on the recommendation of Raghun Committee for ensuring fair competition and ushering economic development in country. The primary aim of this piece of legislation is to avert practices having anti-competitive effects for the advancement of competition in the market, to safeguard the interest of the consumers, to guarantee freedom of trade, to market participants. This legislation is the successor of Monopolies and Restrictive Trade Practices Act of 1961. There are certain anti-competitive agreements which was entered between enterprises, persons or association of enterprises or persons in pursuance of production, distribution, supply, storage or control of products or services, which have a tendency to result in appreciable adverse effect on competition, that is AAEC, within the jurisdiction are referred to as anti-competitive agreements and they shall be declared void. Based on business sharing agreements and evidence of the opposite parties having met one day before the submission of the tender, the CCI held that there was a conclusive proof of bid rigging and collusive bidding by the OPs, satisfying the requirements of contravention under subsection 3D of the Competition Act. An enterprise including cartel shall be presumed to have an appreciable adverse effect on competition and shall be considered as anti-competitive per se. So if they result in following conditions like determination of sale prices, output control, market allocation, bid rigging or collusive bidding. And then there's vertical agreements. So vertical agreements are agreements between persons and enterprises at different levels of the production chain in distinct market in relation to production, distribution, supply, storage or price of goods or provisions of services. Unlike horizontal agreements, vertical agreements are not anti-competitive per se, and it needs to be established that the alleged activity has caused an appreciable adverse effect on the competition in the country. Vertical agreements also comprises tie-in agreement, exclusive supply agreement, exclusive distribution agreement, refusal to deal, and resale price maintenance. Well, they are in detail discussed in your section. You can, in your study material, you can explore. I think they are easy to grasp as well. Then there is the concept of relevant market. Under the statutory framework of the Competition Act, the delineation of the relevant market is of utmost significance. For an abuse of dominance, investigation and enterprise shall be considered dominant only if it has attained a position of strength in the relevant market. Well, determination of relevant market is also significant in a combination analyst, where the CCI has to ensure that the proposed combination does not result in appreciable adverse effect on competition. Well, then there is a concept of abuse of dominance. Under the competition law, mere dominance exerted by a firm is neither considered bad or nor held punishable. However, the abuse of its dominance by an enterprise merits investigation by the competition authorities. This is contrast with the earlier legislation framework as under erstwhile MRTP Act. Violations was gauged based on the size of an enterprise rather than abusive conduct of the latter. Mergers and combinations. One of the significant business development in the field of corporate law has been the plethora of transactions encompassing mergers and acquisitions. The rationale behind companies opting to merge may range from increasing market power, economies of scope, economies of scale, synergistic gain, eliminating competition, and obtaining access to R&D and technological know-how of one to each other. Well, then enforcement of competition law. The Competition Law Act also provides a multi-tiered enforcement mechanism. Well, it can inquire into alleged infringement of Section 3, subsection 1, and Section 4, subsection 1 of the Act based on its own motion or on receipt of an information or by reference received from a central government, state government, or any statutory authority. Under the statute, there is no locus standi requirement. The CCI, after the receipt of the information, is expected to satisfy itself as to the existence of prima facie case and pass directions to the DG under Section 26, subsection 1 for initiating investigation. And there is a structure, DG, Competition Commission of India, and Appellate Authority. In last unit, the Appellate Authority, in case of one judgment is passed, the aggrieved party has a right to appeal through the respective mechanism. And let's move to the last unit of this course, that is consumer protection law. As I mentioned in the very beginning, definitely the business law definitely not only deal with the business establishments and relevant components, but also look after the receiver of the business, that is the consumer, or whosoever is a receiver of product of the market, that is the consumer. Well, when we look back in the history in 1930, when USA was facing great recession, their president Herbert Hoover, while addressing the Congress, had remarked, "Economic depression cannot be cured by legislative action or executive pronouncement. Economic wounds must be healed by the action of the cells of the economic body, the producers and consumers themselves." Well, in a free economy, the service standard product services has to be sacrificed for producers, providers of quality goods, services, which will have an overall impact on the economy. Well, the evolution of consumer protection, we can see it's not a new concept. Our ancient Indian texts, including Kautilya's Arthashastra, the Modern Consumer Movement Worldwide Initiative, when US President John F. Kennedy on 15 March 1952 referred to 4 consumer rights in his famous speech in the US Congress. Thereby, 15th March was celebrated as World Consumer Rights Day on the initiative of Consumer International, that is an international consumer association formerly known as Consumer Union. In 1985, UN adopted the Consumer Protection Guidelines, and one of the mandates of these guidelines for the signatory countries was to pass consumer protection legislations in their respective countries. And fortunately, India, being a signatory to the guideline, became the forerunner to pass the Consumer Protection Act way back in 1986. Well, in view of the above updation, it was deemed expedient to repeal the extant law and enact a new law, namely the Consumer Protection Act, because there was a good number of uh, cases. There has been an increase in the business activities. There has been change in the shift in the global economical scenario, interaction among economies. So that led to the need to change or upgrade in our Consumer Protection Act, which definitely lead to change it in the form of the Consumer Protection Act of 2019, and which was notified in 2020. And this provisions of this act will have impact on revolutionizing an Indian justice delivery system in the consumer cases. This act is really comprehensive and added various new features in the comparison to the erstwhile Act of 1986, and main provisions are covered with special focus on consumer authorities under the Act who can file the case, definition of a consumer, process of filing complaint and online complaint, mediation under the Act, e-commerce issues and challenges, product liability under the Consumer Protection Act, Central Consumer Protection Authority, offenses and penalties. Well, we have seen a new terminology, that is e-commerce, that is evolving over the period of time. So, which was not expected or which was not there in 1986. So, addition to these new terms, concept, and business models has been there to include the rights of a user as well as the responsibility of the producer as well, or business houses as well. There are consumer authorities under the Act that can be, there are basically four types, that is Consumer Protection Councils, Central Consumer Protection Authority, Consumer Dispute Redressal Commissions, and mediation cells. And they are defined under respective sections like section 3 to 9, 10 to 27, 28 to 73, and 74 to 81. There are a good number of powers, specific type of power that is vested upon all the commissions based on their vertical hierarchy. As far as the district commission is concerned, they have the right up to 1 crore, state commission 1 crore to 10 crore, national commission about 10 crore. Well, Supreme Court revision and appellate jurisdiction, National Commission with original review and revision, appellates with the SCDRC and CCPA, State Commission original review, revision, and appellate jurisdiction, District Commission original review and jurisdiction, and district level. So this is a hierarchy with which one can approach for their grievance. And the system of appeal, District Commission to State Commission to National to Supreme Court, and there's a time frame lapsing which one can approach to the next within, like from district to State Commission within 30 days from the date of order, from State to National Commission within again next 30 days from the date of order. Similarly for the Supreme Court as well. Well, what is the procedure for complaint? The section 2, subsection 5 of the Act defines complainant as a consumer, any voluntary consumer association registered under any law for the time being in force, the central government or any state government, the Central Consumer Protection Authority, CCPA, or one or more consumers where there are numerous consumers having the same interest. In case of death of a consumer, his legal heir or legal representative. In case of a consumer being minor, his parent or legal guardian. As far as the definition of the consumer is concerned, Well, it means any person who buys any goods or hires services for consideration and includes any user of such goods with the approval of buyer. But if goods are bought or service are hired for resale or for any commercial purpose, the case falls outside this act. It has also been made clear that if a person used the goods bought exclusively for the purpose of earning his livelihoods by means of self-employment, she is still a consumer and may avail the remedy under the Act. Well, this new act also include online transactions through electronic means, that is on very pace or very high level, especially in case of tele-shopping or direct selling or multi-level marketing. And under Section 2, subsection 6 contains the definition of complaint, which means any allegation in writing made by a complainant for obtaining any relief providing by or under this act, an unfair contract, unfair trade practice, or a restituted practice has been adopted by any trade or service provider. The goods brought by him or agreed to be brought by him suffer from one or more defects. The services hired or availed of or agreed to be hired or availed of by him suffer from any deficiency. If a trader or a service provider, as the case may be, has charged for the goods or for the services mentioned in the complaint a price in excess of the price fixed or by under any law for the time being in force, or be displayed on the goods or any package containing such goods displayed on the price list exhibited by him by or under any law for the time being in force agreed between the parties. Well, there is a specified process for filing the complaints. Well, the complaint containing the relevant facts with supporting document need to be filed before the commission of the competent jurisdiction in writing. There is a procedure for time frame within which to file. There are certain limitations for filing a complaint. The period within which complaint is required to be filed before the commission is 2 years from the date on which the cause of action has arisen. However, a complaint may be entertained after the same period if the complainant satisfies the commission that he had sufficient cause for not filing the complaint within such period. And if such a complaint is entertained by the commission, then reasons for condoning such delay need to be recorded in the judgment as well. Well, relief that can be granted and execution of orders by the consumer forums, removal of defects or deficiencies in the services, replacement of goods, refund of the price paid, award of compensation for the loss of injury suffered, may also award punitive damages, discontinue and not to repeat unfair trade practices or restrictive trade practices, to withdraw hazardous goods from being offered for sale, to cease manufacture of hazardous goods and desist from offering services which are hazardous in nature. Well, if the loss of injury has been suffered by a large number of consumers who are not indefinable conventionally, to pay such sum, not less than 5% of the value of such defective goods or services provided, which shall be determined by the forum. To issue corrective advertisement to neutralize the effect of misleading advertisement, to seize the desist from issuing any misleading advertisement, to provide adequate cost to parties. Well, you can see there are some new types of orders that may be passed by a consumer for the under 2019 Act, which will improve effectiveness of the Act, particularly in the area of misleading advertisements. Well, the order against airing company or individual to issue a corrective advertisement in case of misleading advertisement to neutralize the effect at their cost. It will improve effective to curb the menace of misleading advertisement, because you can see many advertisements which talk about fairness cream or so. So there has been regular cases, representations and complaint with which you can see there has been change in those advertisements. And at the same time, because one of the major component or major part of expenditure in industry, specifically in big industry, is the cost of advertisements. So those advertisements involving brand ambassadors, very leading figures. So all those put up certain effects on the mind of consumers that may be psychological. So if a celebrity is claiming some benefits out of a product, so usually it attracts the follower of that celebrity in a big way. Definitely industry is exploring that aspect to attract new customers. So in order to address the issue of misleading advertisement, claiming something that cannot be proved, they can be sued, and they need to issue necessary directions. So you can see like a good number of gaming apps related advertisements are there on your screen, but at the same time there is a caption or disclaimer in the ad that this has got vittya jokhim, like financial risks are associated with this. Addiction of financial risks are there. So the company need to put such disclaimer as well. At the same time, you can see, which was not there in previous time, whenever there is a scene of a smoking, be it serial, be it a movie, or be it advertisement, definitely. So advertisements are not there in the public forum. So in any TV serial, movie, or any place, whenever there is a scene of smoking, so there is a mandatory display of a logo or a signage that smoking is injurious to your health, even on the previous movies also. So you can see this all has been the result of activity of our judicial system. Then there are certain product liabilities, which are also mentioned in the Act of 2019. As I mentioned, there is a concept of e-commerce that has been evolved. So the e-commerce is also coming under the rule 2020, and it applicable as the rules apply to all goods and services bought or sold over digital electronic network, including digital products. All model of e-commerce, including marketplace, inventory model, or whatsoever model is followed. All e-commerce retail, including multi-channel, single brand retailers and single brand retailers in the single or multiple formats. All forms of unfair trade practice across all models of e-commerce. Well, every e-commerce entity shall provide the following information in a clear, accessible manner, like legal name of e-commerce entity, principal geographical address of the headquarters, name and details of its website, contact details like email address, fax, landline, mobile numbers of customers care, as well as to grievance officers. No e-commerce entity shall adopt any unfair trade practice, whether in the course of business or on its platform or otherwise. Well, no e-commerce entity shall manipulate, discriminate. Well, there are liabilities associated with the e-commerce activities. There are certain duties that are defined for the sellers on marketplace. Well, there are duties and liabilities of inventory of e-commerce entities, accuracy notice, then they should not be falsely represent, they should not refuse take back their goods, and there are certain contravention rules regarding it has been regularly amended and they can be enforced. There are regular penalties associated with this, and then there is a provision for mediation as well. That is the landmark feature on this side. So far, mediation is a process where parties to dispute voluntarily try to settle their dispute amicably. Well, it is a consensual process where the party can exit anytime they want. The process for mediation is a closed process and is totally confidential in nature. So with this, we can summarize that the business laws cover a broad spectrum from starting of a business entity, type of business entity, to the consumer aspect, to the environment aspect, as well as to the aspect of the evolving business models, that is e-commerce as well. and all the aspects, including setting up, including disputes or dispute resolution, is taken up in the business. And definitely, it's a evolving process. Whatsoever is lacking will be addressed in the upcoming days. So, with this, thank you very much for being with the session. Namaskar.